If any person is charged with a criminal offense, then the case shall be afforded a fair hearing. The case, not the accused. Of course, the accused also must be afforded a fair trial, but he's not the only one. It is also witnesses, victims. And there are many stories. There are these sexual offenses where a girl of 16 is raped. And then it takes 16 years or 14 years before that case is tried. What kind of justice is that? Now, this lady now is 30. She may be married, she may have children, she may have never told her husband about what happened to her when she was 16. And now you have to appear before the court and tell it all over again. So it's no wonder that witnesses are not very happy to do that. And that means that evidence evaporates, and therefore a guilty person might be free. Witnesses have to be called by the magistrate's court. They come, they wait for hours, they are sent back, come back next month, etc., etc. That is not fair to witnesses. So, and of course, there must be fairness to the society. We talk about sentencing and so, but what is more important is detection rates. Now take Trinidad and Tobago, unfortunately, but there is a very low detection rate. Of all these murders, it's lower than 20%. And of those 20%, there is an acquittal rate, as I have been told, of more than 60% or 70%. So a very low conviction rate on top of that. This is not a way to run a criminal justice system. What we said also, it is true that a criminal justice system must be fair and must be seen to be fair, but above all, it must be effective in protecting the rights of all. In fact, a profusely ineffective criminal justice system can hardly ever be fair. So we recognize that the system as it is now functioning, or actually dysfunctioning, needs a thorough overhaul. There needs to be very profound a look at our criminal justice system. And as we know, in Trinidad, it's well publicly known that there will be people who will be on remand waiting for their trial. And mind you, we still say they are innocent until proven guilty. They will be waiting for more than 10 years in some cases. That cannot be justice at all. We really need to have a good look, a robust look, a merciless look at our systems and see how it is that it dysfunctions. And there are 3 ways at this moment that we suggest you might be able to get through, to create a strong pre-trial process. I think the Attorney General already mentioned something in this respect. There must be a sifting of cases, because if more than, let's say, 70% ends with acquittals, there must be something wrong with the system. In any properly functioning system, acquittals might be not more than 10%. And why? Because in the process, before you get to the trial, there must be a sifting process. If cases simply do not have sufficient evidence, they need to end in a release. We can't do anything about it. We cannot keep people in jail while you know that there is not sufficient evidence. And there must be some guidance from a pretrial judge to get through the process. So that is one way of dealing with it. There needs to be much more plea bargaining. That is what the Americans do. 70% of all the cases are plea bargained in the States. That's why they can get their cases done. That is only very small here. And the third point is improve and broaden the judge-alone trials. And there are many ways you can do that.